Hello, YouTube. I'm Vince White. I'm an employment attorney, and on this channel, we answer publicly posted questions from YouTube users, getting folks the answer they need from an employment attorney. But today we're dealing with a Supreme Court decision in our current events themed playlist. All right, so here's what happened. Got a lot of emails about this. Friend of the channel, David, commented about this, contacted me about this, and first and foremost, let's give this story. Let's give the story so you understand what's happening here, because I've actually seen it reported inaccurately, repeatedly. So there was this concrete company, and the workers of this concrete company were in a union. They were negotiating their new contract. It wasn't going the way they wanted, so they decided to go on strike. So the strike began after work had already begun for the day. Now, it's a concrete company, so they have concrete trucks. And when work began for the day, they put concrete in the trucks, got it wet, got it going, right? Made the concrete out of the concrete components, powder, whatever you want to call it. And then here's where a lot of reporters got this straight up wrong. A lot of reporters said, well, the strike began after the work had begun for the day, so the workers left concrete wet in the trucks and did not leave the trucks running. The back of a concrete truck that rolls, keeping the concrete moving, keeping it from setting. A lot of the reporting on this topic that I've seen represented that the trucks were not left rotating to keep the concrete from setting. And so it endangered the trucks, and ultimately the trucks were damaged and or destroyed by the strike. From what I've been able to gather from better reporters, frankly, is that is not at all accurate. What actually happened was this. The strike began after work had begun for the day. Wet concrete was in the trucks. The employer was aware the strike was beginning. They informed the employer. And the workers, in an attempt to mitigate damage to the trucks, left the trucks with sufficient water in the trucks and with the trucks running to keep the concrete from setting. So the employer was notified, come get your trucks. They have wet concrete in them. And we did everything we could to mitigate, to make sure that wet concrete does not harm your trucks. But we're on strike, and you knew this. It was scheduled. This is not a wildcat strike. This was a legal strike under the laws of the U.S. in compliance with our various statutes and NLRB rulings and this and that, right? And it's of note that almost all wildcat strikes in the U.S., sudden strikes where workers just unannounced walk off the job, those are almost always illegal in the U.S. So, which frankly is what was one of the most powerful tactics of unions back in the day, the wildcat strike. Just calling the strike and everybody walking off, that was brutal for a lot of employers and a huge source of leverage for unions. That is not legal in the U.S. So this employer was not blindsided by this strike. Huge difference though, right? The original misreporting of the story was that these trucks were destroyed on purpose by the workers, essentially going on strike. Didn't happen. That's fake. That's entirely fake. All of that was just lies based on what I've been able to ascertain. Now, what we know really happened was sufficient water, trucks were left in motion, the concrete was wet, and the employer was on notice of the status of the concrete. We also know the trucks were generally not harmed by this, right? The employer had enough folks. They were able to take steps to make sure the trucks were not damaged, and the strike went on. Then the employer sues the union workers, and says, hey, you caused us harm by going on strike. That is the purpose of going on strike, is to cause economic harm. That is how it becomes a source of leverage in negotiations. So I would imagine, yes, they did cause economic harm. That's how that works. Now, they're not saying, though, as I understand the lawsuit, and we'll get to the lawsuit in a second, it appears the claim is not that they experienced economic harm because they couldn't work for the day. it appears the argument they're making is that the product, the cement that was wetted and put in the trucks, was then wasted, and they lost the value of that cement. Apparently, it was considerable value. Okay. I mean, a bit problematic because they knew the strike was going to happen. It wasn't a wildcat strike, so you could have directed the employees to not put the concrete in the trucks if you wanted, I presume. But okay, so the employer pursues this lawsuit against the union and the employees. State court finds you can't sue for this. This is something that should go to the National Labor Relations Board. Appeal. We're at the Supreme Court of the United States, and near unanimously, they found that the employer can go forward with this lawsuit against these union members, against the union, for the damage done, I guess, in the waste of that product, the concrete mix, right? When David sent me this article, friend of the channel David, the first thing out of my mouth was, oh God, this is going to cause so much litigation. Which I should be happy about. I'm an employment attorney. I should like employment litigation. It gives me good things in my life. But I don't like this one because it hurts unions pretty considerably. And even the dissent here, Justice Katanji Brown dissented from the finding, the near unanimous finding that the employer could sue for this damage, for this harm. But her dissent didn't really make sense to me, to be honest with you. Her dissent was that the court didn't have the jurisdiction, the purview to decide this, that it was a question for the NLRB. Questions there. Supreme Court's mission, as I understand it, is to adjudicate the findings of the federal government and to ensure the rights of the populace and whatnot. So how could an unelected official at the NLRB level make a decision that was not within the purview of the Supreme Court? Questions about that. Certainly. I also have questions about the idea that a court finding at any level that impacts questions that would go before the Supreme Court. I have questions as to why that would not be within the purview of the Supreme Court. So, I don't questions about her dissent, Justice Katanji Brown's dissent, but more importantly, I think it's worth noting that both the liberal and the conservative justices on the court really, with the exception of Justice Katanji Brown, all the other justices were in lockstep on this, as was, unfortunately, the Biden administration, as this was the ultimate finding that they were pushing for out of the Supreme Court. So that's depressing. That's depressing, right? I mean, both political parties make little theatrical attempts to appear to be pro-worker at various times of the year. But when it comes down to it, here we see them, both sides of the court, and the most employee-loving president of all time, Joseph Robinette Biden, all pushing for a bad decision for workers. And obviously I'm being facetious. I don't think President Biden has been in any way worker supportive during his presidency. But that being said, this is now a scary thing going on in organized labor that unions are going to have to deal with. It has set back organized labor rather significantly. There's going to be a lot more litigation now. And generally, I am a little bit unhappy, a little bit frustrated with this finding. I'm going to link a news article about this below, just so you can get a little bit more information than I provided here. I believe this article to be one of the most accurate. So, hope it has some value in that sense. Speaking of value, if this video had value to you, if this was helpful in any way, like, subscribe, comment down below. It helps me to help more people just like you. Remember, not everybody works, but everybody will eventually get screwed over by the government. Take care.